Good morning, everyone. It's your friend Rick. It is, excuse me, July 29th, 2017. If you need to contact me, it's rick0327@me.com. And let me just start the video off. Somebody emailed me, reaching out, and this guy didn't think it was anything wrong. He was just like, all right, so when I get the paperwork, I can start asking for donations, because I know a lot of people here that have child support problems. I go, do you mean taking my paperwork and then reselling them? And basically he was like, yeah, because some guy I know is taking your paperwork and he's selling them for $850. God almighty. And now you guys know why sometimes when I do a video I sound like I'm burnt out. It's unbelievable some of the stuff that I got to deal with. And I'm seriously considering getting a web page started and hiding behind the web page, like a couple of channels do, because I have to deal with all different types of people. I got to deal with the con man. I got to deal with the person who's taking medication, or probably should be taking medication, up all night, emailing me all night and accusing me of being a government agent, and I got another idiot, accusing me of being loyal to the police, and ripping apart what I do. When he knows how hard this is to get done. Right, Terry? Right? Didn't you have your case in federal court thrown out? Huh? So you know how hard this is. So, it's easy for him to say, yeah, he's full of shit. He's got no proof. He's almost 50 years old, which means that my children aged out, and that's why they vacated. No, that's not the reason why, idiot. Where I come from, 50 years old is not that old. A lot of people where I come from, 50 years old, they have children that are 5 years old. Okay? So, I know my paperwork works. You know why also? On Wednesday, and Osiris reached out to me to give him a call. I gave him a call. And he's like, listen, I just want to let you know, he goes, I have it on good authority, people that I know on the inside, that they're dismissing our paperwork because they know what we're doing. They know about our channels. They know they're watching us, trust me. They're watching us. And they know that most people will go away or get frustrated by the first no. Okay? And he told me, he says, you're not doing anything wrong, so don't get frustrated. Just keep fighting a good fight. And we just gotta, that's why I'm gonna do the video but I gotta do the video explaining to you what you have to do with the Writ of Mandamus and why you're doing it. Because what a Writ of Mandamus does is that a higher court, meaning the lower courts we go into, these court of common pleas, all the courts that we talk about, family court, whatever. The next court above that is it's either the appellate court. Like in New York, this is the way it works. In New York, we have the family court. And then you have the Supreme Court. Now, the Supreme Court has different divisions. They have the appellate division, the appeals division, but the Supreme Court retains original jurisdiction in law and equity. So, family court is an administrative court. It's a statutory court created by the New York legislature. All right, so that means that it falls under the umbrella of the Supreme Court. So whenever there's a mistake or somebody's not doing their job, you go to that higher court. That's like going to the parent. You know, your son or your daughter's not behaving at school. You go to the parent, and the parent has to tell the child to behave themselves. That's basically what a writ of mandamus does, is to make sure that the person, you know, that they're not performing their duty, or they're using discretion, which they're not allowed to use. You have a job, and in the functions of the job, I always use the support magistrate here in New York, Family Court Act 439. If that support magistrate performs a duty, a ministerial duty, outside of the duties, you know, prescribed in 439, it's void for exceeding jurisdiction, or abuse of discretion. Okay, so then you have to go to the next court, which is what I'm trying to explain to you. In New York, it's called the Article 78. And Article 78 has all three of the writs: mandamus, prohibition, and certiorari. Now, every state is different, but they're in every state. It's an administrative, it's a judicial review of an administrative function or action. And there's a famous case law that I found through my research, that whenever this case law is properly used, it hasn't been overturned yet, and people have never lost when using it. The hard part is, you know, making sure you're doing everything just right. It's called Marbury versus Madison, which basically says is that you know, any administrative act still must be within the Constitution of the United States. Okay. It's also the Administrative Protection Act. Okay. There's a lot of remedies, but what it is, it's so when you do the writ of mandamus, it's for redress and remedy of an administrative act or an administrative officer exceeding jurisdiction. Also, the higher court, let's say you have a judge in that lower court, and that judge is ignoring stare or star decisis, DECESIS, STAREDECISIS, stare decisis. Easier for me to spell it than pronounce it. All right, but what that is that the judge, the Supreme Court, let's say, we'll go right to the top. Supreme Court, that's the reason why they're there. They're there to oversee interpretations of the law, and they're the final overseers. They're the final, it's like a writ of mandamus to them. They're the final judicial review, and their opinion counts. And then their opinion must be complied with by the lower courts under 28 U.S.C. 2072. So, like, we'll take for argument's sake the Burnham versus Superior Court decision of 1990 that said, now there was a bunch of other, but that was the last time it was used in a Supreme Court setting. But, you know, they had a lot of Supreme Court decisions in the 1800s. Remember my video I did a while ago about it, that it was used a lot in the 1800s, which said, the Burnham case said that any act committed by a non-judicial person is void for lack of jurisdiction. Now, here's another, for instance. In New York State, and maybe your state as well, what they do is they'll have a judge sign off on findings of fact from a fact finder. A support magistrate is really a fact finder. You go before her or him and present facts. He or she gathers the facts and then presents it. This is the way it's supposed to be. In New York State, under Family Court Act 439, it's supposed to be signed by a judge or it lacks judicial force. I've said this numerous times, but I keep saying it that way, it registers. And every state, I guarantee you, it's the same thing. So if you're like before a commissioner or a judicial official in California or a magisterial officer or magisterial judge in Pennsylvania, it still has to be signed by a judge or judicial review. But here's the problem. Under Burnham, if there's no judicial officer in the room, there's no judicial official, there's no judicial authority. So that means even that order is void. So if you have an order signed by a judge that you've never seen before, and this happened in my case, it's void for lack of judicial authority or lack of jurisdiction. Okay, I mean, it sounds complicated, but it's really not. But it's a wonderful case law for us, okay? Because many of us have these orders by these fake judges, okay? And now, by writ of mandamus, we can go to the higher court and have that higher court force the lower court to comply with precedents of, Supreme Court case, Federal Court of Appeals, basically any court in the United States. They don't like to do that. Like each state would prefer to use their own case law, meaning, court cases from their own courts. So, like, again, I use New York because I'm from New York. They'll routinely cite appellate court decisions and Court of Appeals decisions. Okay? But you can use a federal decision. Okay? Because ultimately, everything is supposed to be in compliance with the federal authority or the federal laws of the United States. Okay? Like, I'll give you an example for Court of the Supreme Court. SCOTUS, SCOTUS. Just remember that, SCOTUS, Supreme Court SC of the United States. You can use that in your paperwork. You can write your paperwork. The Supreme Court of the United States, here in after SCOTUS, meaning that when you use it in the rest of your paperwork, it's SCOTUS. That way you can cut down on, you get lazy. I get lazy. So, it's the famous case in the 70s of Roe versus Wade. Maybe you guys have heard it on the news. It's always brought up in all the presidential cycles. Are you for or against abortion? Okay, and the famous case is Roe versus Wade, which said that a woman has the right to have an abortion. It's her body. She could do what she wants with it. Okay, so you could take that in any state court and say, okay, well, the Supreme Court says, let's say you're a woman and you go into, you want to get an abortion in your state, and then your state passes a law that says abortions are not allowed in the state of, you will go and say, well, the Supreme Court has held, and that's it, it's over. Okay, but that's a political case. So they'll stay away from that. I'll give you another case law. Miranda versus Arizona. Miranda is when, we watch all these movies. You have the right to remain silent. But it goes beyond that. What Miranda really is that the state cannot create rules and procedures that deprive you of your rights guaranteed in the Constitution. That's what that case is famous for. Okay, so a state cannot, but look, family court, all the family, I always say family court, and if I sound like I repeat myself, I do it because you don't know the questions I get sometimes. Sometimes the stuff that I think is very obvious to me, people don't get right away. And, it's just the way it is. Like some of my paperwork, I forgot to put the line on the bottom to sign your name. And people are like, Rick, do I sign my name? I'm like, of course. Paperwork is worth nothing without your signature, without your autograph. All right? That's my fault for not having it there. But again, that's another famous Supreme Court case. Is the state cannot create, or an agency cannot create a rule that deprives you of a guarantee in the Constitution. Okay? And what I'm finding is, and it makes sense, that's why I'm glad that and Osiris reached out to me, because it's because they're knuckling down, they're pushing back. They know we're right. Okay? One of my subscribers, Milton, sent in the validation of debt, and he got a response to he sent it to the child support agency in New York, and he got a response from an attorney, and it's definitely pre-written. It's like a pre-written response. It has to be for me. I know that they're watching me. And the response was the courts held in the Fair Debt Collection Practice, blah, 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 blah. So Milton wrote a great response, was like, I never brought up the Fair Debt Collection Practices Act. Why are you bringing it up? It's because it's pre-written. Okay? And so that's what we're going up against. So I'm going to end the video. Let me overview. Hey, please, my paperwork is not for you to buy and then, or you're not buying it, you give me a donation. It's not to get it and then victimize other people so you can make money. It's a scumbag move. I mean, when I got that email, I was livid. $850 for my paperwork. So somebody got it from me, probably for $100. That's right, I asked for more now because I've added a lot more paperwork. But so somebody thinks they're an entrepreneur and taking my paperwork and my hard work, and then they're going to make money on it. When the reason why I charge so cheap is I'm trying to help people. Most people cannot afford $800. And there are a couple of channels out there that are in that ballpark. $750. $2,000. Okay, I know somebody that got grabbed for $2,000. And I saw the paperwork. My paperwork blows it away. Okay? And I made my point there. My ears are getting red. Or is it from the air conditioning in my car? But also, understand the reason why we're going to do the writ of mandamus. Don't get frustrated with the dismissal. The next move is the writ of mandamus. We're not going to do an appeal yet. Because if we can get the court by the writ of mandamus to force them to just, listen, you got to perform this duty. And the duty is you have to recognize the Supreme Court case. So if you have an order issued by a non-judicial person, oh my God, this is huge. And then to get a higher court to tell them they have to recognize it, there's a lot of hope. And sometimes that's all we need is hope. All right? And then I explained to you the importance of Supreme Court cases and how we apply them. All right? I know I'm telling you guys, any day now, the writ of mandamus, it's coming. Okay? Maybe later on this afternoon. All right? And I told you, whoever has my paperwork, it's another donation for that. Okay? Because it's a different court. It's a completely different ballgame. All right? And also with the writ of mandamus, you could take all of the other stuff that you have gathered now to support your case. But that's also gathered for you if you have to file an appeal down the road. Hopefully you won't have to. Okay? And with that, enjoy the rest of your days. Or day.